Hello, good evening. I'm Oana Stefan, and I'm a reader-in-law at King's and the Vincent Wright Chair in Sciences Po Paris. Welcome to this Center of European Law seminar on the European response to the war in Ukraine, a legal analysis. It is a topic that we have hoped not to have to discuss. However, today marks 2 weeks since the abominable Russian invasion of Ukraine. And war and humanitarian disaster are unfortunately and once again high on the agenda. We are welcoming tonight a stellar lineup of speakers and are especially grateful that Professor Roman Petrov from the National University of Kyiv-Mohyla Academy has agreed to come and talk to us during these very difficult and busy days of duty to his country. This seminar is recorded. Participants can use the Q&A function of Zoom, and you will find this if you hover your screen just at the bottom to ask the questions. And after we hear from panelists, I will group questions from the Q&A and ask them to our panelists. And we will now hear from Professor Roman Petrov, who is head of Jean Monnet Center of Excellence and Jean Monnet Chair in EU Law at the National University of Kyiv-Mohyla Academy. He has been conducting research on EU law and held posts in various institutions such as the European University Institute in Florence, Oxford, Heidelberg, Augsburg, Ghent, and Riga, and is the author of the first Ukrainian textbooks of EU law. He is the founder and the first elected president of the Ukrainian European Studies Association. Roman has been also an investigator with UNPAC, a Horizon 2020 project examining whether EU external crisis response is sensitive to political and social context on the ground. He is also the co-editor of the recently published Unrecognized Entities, Perspectives in International, European and Constitutional Law, which studies the legal and political status of non-recognized entities and covers, among others, non-recognized entities in Eastern Ukraine. Roman, the question that we have here is, in what ways can European law help the situation? Does it help the situation? And what can we all do to help? The floor is yours.
Thank you. Thank you very much for your introduction. It's a great pleasure to be together online with my fellow colleagues whom I know very well, and we've been working on various projects and publications. Great pleasure. In course of my time share what I was given, I would like to briefly guide and explain you the situation in Ukraine, current situation, especially in field of higher education research. And then I will look at your main question, how EU law can help and how it could be relevant for Ukraine, to give you just general background, how it can work. So first, about the situation, general situation. I think you learned a lot from mass media. I personally start my every morning not with the Ukrainian press, but with BBC, and I must admit that BBC Radio Online provides very good overview as well as other resources. So it's widely accessible. Just some personal remarks and general observations. Of course, first, it's always a bit of a test for every person to cross this borderline of considering war as a subject of study, subject of entertainment when you watch films and reading books, to your personal experience. And when suddenly you wake up in the morning, early in the morning, because of strange sounds which appear suddenly as shelling, it's all suddenly, of course, changes considerably your lives, views, and certainly behavior. So I basically share fate of all my fellows in the country. So I left my hometown, home city Kyiv, with my family. Half of my family has been evacuated to the EU, and I personally experienced this very warm feeling when my family was, once it crossed the Polish border, was hosted by College of Europe, Natolin campus, and my colleagues, EU law professors, they did everything possible to to provide their facilities to host women and children and to provide them with necessary shelter. And I was really impressed. And I was impressed how volunteer and host services in Poland, and now my family is in Germany, work there. So I think if again, talking from a personal background, I think this Europe has been criticized for many years, and we all know, for its inefficiency and restraint dealing with so-called migrant crisis. I now being personally involved into it, I never thought about it. I can see that at least at this point, I can claim that the EU has successfully met this challenge, especially some EU member states, and hopefully it will manage to keep its speed and face decently in the future, because unfortunately we may expect up to 5 million Ukrainian refugees coming to the EU. Situation in the country is surprisingly more or less stable, because all major infrastructure functions, and people don't experience ordeals everywhere except to the combat zones. Unfortunately, major university centers and big cities like Kharkiv, Sumy, Mariupol, they're on the verge of humanitarian catastrophe. And of course, it's a great challenge for international law and international humanitarian law lawyers how to qualify and how to take Russia responsible for all these atrocities what happen. And therefore, all this ordeal caused mass migration within the country. Basically, Western cities like Lviv, Ternopil, Ivano-Frankivsk, and others, they have fled with people from Kyiv and from the east. And we all try to cope with this as much as we can. We, of course, all quite not even surprised, but we are proud of our military, of our army being able, and also local militia being able to provide resistance, really national-wide movement. People do everything possible. Lots of people volunteer. So it's actually very rare moment in Ukrainian history when we even didn't experience in times of our two revolutions, when the whole country really shows solidarity in patriotism and self-assistance and defense. So it's truly a historical moment for all of us. To tackle briefly situation in the field of higher education, it's also a challenge for us, because there is no teaching. Teaching is terminated. We are on a forced break. Spring break, so to say. Most of the members of staff are on run. Lots of female scholars, they left the country with their families, with their kids. Men stay mostly until 60. They stay in the country. They're not allowed to leave. We are now considering ways how to resume teaching and research, but it's of course difficult because also many students left. It tells us that we are facing a huge brain drain, because it's obvious that not all scholars are going to come back. And therefore, now we are looking for ways how to at least give opportunity to our students to complete their study online, possibly engaging Western universities. There are many initiatives, and I'm now being involved how to ask Western universities to open their online resources for Ukrainian students in order to help them to complete their academic year. As well as there is a kind of circulating idea initiative to open at least kind of a hub, sort of open Ukrainian universities where prominent international scholars could come and at least give some guest lectures. So many ideas are being discussed. It's only part of the challenges to what we are facing. So infrastructure damage is considerable. It's today I read an approximate estimation about $100 billion or maybe euros, which is already all major airports, unfortunately, not functional, and some of them are destroyed. So Ukraine certainly is going to face major infrastructure challenge to recover its facilities. But furthermore, what we are now even, of course, you're aware about this emerging nuclear threats. We are all concerned, of course, as well as you are, because two our major, Chernobyl, it doesn't function, but still it's dangerous. But Zaporizhia is largest in Europe, at least. It's out of our control. There are two more, or even three more nuclear stations in operation controlled by Ukraine. It's one challenge. Another challenge, of course, it's for coming agriculture season. As you know, Ukraine is a major producer of wheat, and of course, inability to start the agriculture season and to collect harvest would reflect not only on food stability and security, not only in Ukraine, but abroad. And it's also a major concern for us. So everyone is interested to stop this war. However, swiftly going to the topic of EU law, we are all following, as people say, that our army has done its best, but now only hope to engage diplomats to reach a solution. And as you know, today in first meeting between the foreign minister of Ukraine and Russia took place without any result. Why? Because you all know conditions of Russia, which it wants to impose on Ukraine, which right now are not acceptable. And some of these conditions, it's apart from so-called demilitarization. No one now speaks about denazification. We don't know what it means, but one of the conditions is a sort of neutrality, which implies refusal of Ukraine to aspire membership with the NATO and the EU, as it says now. So moving to the field of EU law, first of all, I would like to mention that the whole aggression or the war was masterfully shadowed and devised by the Russian side as a peace, not even how special operation to prevent genocide from the Ukrainian side. So there is lots of work now for our international lawyers to clarify these issues, to take Russia responsible for the crimes, especially as you have heard, first hearings took place at the International Court of Justice in The Hague, where Ukraine wants to prove that International Convention on Prevention of Genocide cannot be used as a pretext for military aggression. So we're now trying to use all possible means to protect our interests, as well as now there is a growing discussion and a movement how to lobby the creation of a special tribunal on Ukraine to consider to all these violations of international humanitarian law, as well as other issues related to the Rome Statute. So international lawyers are quite busy. Are the EU lawyers busy? Not really, not too much. Until February 24, we've been busy. We had been doing lots of stuff related to the implementation of the EU-Ukraine Association Agreement. Now it's not, of course, on the front line anymore. So we had several meetings, including, of course, with EU law experts all over Europe. There was an initiative group. We had a meeting with the representatives of the external service of the EU. And we realized that the only security provision which actually relevant for Ukraine and sort of could be somehow used, as we thought at that time, is Article 9 of the Association Agreement about the regional stability, which mentions mutual assistance. It was kind of a hidden clause of mutual security assistance, of course, without any promises, but it doesn't have any real, and it didn't have any real value, because when it was negotiated, of course, security situation was different, and the meaning of this regional stability cooperation had a different connotation, of course, at that time. So now, of course, what is most discussed and most explored issue in within the EU-Ukraine relations Of course, this recent application of Ukraine on behalf of the Ukrainian president for the membership in the EU, it was done by the letter of the president of Ukraine on February 28th. We all know that any European country, according to the Treaty of the European Union, may apply. And this major criteria of Ukraine as a European country, of course, was confirmed in the preamble of the EU-Ukraine Association Agreement. It was a big deal at that time. It was a compromise. Instead of recognizing any right for Ukraine to be considered as a candidate country, a preamble of the EU-Ukraine Association Agreement contains this clear-cut provision recognizing Ukraine as a European country, thereby allowing Ukraine to apply anytime. Of course, the Ukrainian government considered this chance and opportunity as a special case to be triggered in a special circumstances. So possibly on February 28th, in times of the just launched aggression, the Ukrainian government, especially the office of the president of Ukraine, decided to trigger this provision. Why they did it? Of course, I can only share my personal observations, because the sort of recognition of the possibility of membership of Ukraine in the EU always has been considered as a very important moral boost factor for Ukrainians. And I was quite reserved on this statement and on this on using this possibility in these circumstances all the time. But I must admit that today, in today's circumstances, it's possibly a very important step to do, because any sort of moral support and moral assistance is important for Ukrainians, especially knowing quite harsh demands on behalf of the Russian government as a pretext of introducing a ceasefire. And therefore, there is a kind of expectation that the EU would be at least willing, if not start a negotiation process. And we all know that it's not so straightforward. It takes years and years, and it can be halted at any time. And of course, there is no need to explain, even for Ukrainian populations, that it doesn't imply anything in the near future. Nevertheless, of course, mere fact of recognizing Ukraine as a even potential candidate country would certainly be a good, important contribution to the course in the recent situation in Ukraine. Of course, what I learned just today before this meeting, we all know statements of President Macron and other leaders. There is a meeting, I think, of the European Council, yes, and of course, France, Macron as the head of the EU Council, he's not inclined to consider this Ukraine as a candidate country, because it's a belligerent country at the moment. Which is understandable, but I don't know what consequences could be, and certainly it weakens Ukraine negotiating position. So it's about this issue, and I hope it's going to be discussed with the colleagues later on. Other issues, my personal observations that in general, I think that EU-Ukraine relations, they worked quite well in times of crisis. I must again reiterate that the EU managed to meet this challenge of massive influx of Ukrainian refugees with destiny, and so far it's been managed quite well. It's what I know from my family, from my friends' families, and it's probably one of the best pages of our mutual relations. Of course, sanctions and being appreciated, but there is another issue of the effectiveness of sanctions, which also must be a subject of sober academic and expert evaluation. Of course, there is an emergency aid which is now being unleashed and offered to Ukraine, and it's also very quite valuable and important. Of course, the most important for Ukraine is to resume to reinvigorate our economy, and we don't know when we are going to be able to do it. It's very important. If generally to consider this emergency a style of a mutual assistance, special assistance on behalf of the EU. I must admit that it's been done quite well. But of course, Ukraine, in a long perspective, would be interested in taking more active part in the common defense and security policy initiatives. It has been already quite a long story and discussion, but we all know that the EU is not ready to do it, or apart from some sporadic cooperation projects. And possibly in the future, it's going to be again subject of discussion. So shortly answering your question, how EU law could work and helpful, I think that a major assistance, what I expect, has been provided. We all understand that the EU itself is going to face some difficult situations, especially with regard to the energy and gas supply and oil supply from Russia, especially Germany. We all understand it. We understand that all the sanctions, they also not only harm, they also of course harm the Russian economy, but also would reflect on the EU. It's understandable, but certainly it must be admitted that even if the conflict, the war is over very soon, EU-Ukraine relations would not be the same and cannot be the same as they were before. As a protagonist of the EU-Ukraine Association Agreement, I must again reiterate it and admit that it's already outdated, and it was created, negotiated in completely different geopolitical and economic circumstances, and the EU and Ukraine will face, as well as, of course, as we must consider Georgia and Moldova, completely new format of bilateral relations in the future, of course. So we are facing quite interesting times, and hopefully our expertise will be valuable and needed in these difficult times. I think I'm within the time limit. Thank you very much, and I would be later on happy to answer questions. Thank you.
Thank you so much, Roman, for this, and we'll definitely get back to you for questions. And now, what I'm going to do is to give the floor to Luigi Lonardo, who is a lecturer in European Union law at University College Cork since 2020. And that's when he graduated from King's College with a PhD, with a thesis, which was awarded by the European Law Faculties Association. His thesis explained and systematized the interpretations of the intricate legal issues of common foreign and security policy given by EU institutions, drawing from literature on European integration, as well as from classic works of political thought. Luigi works on European Union's foreign affairs from a legal, historical, and political perspective, as well as looking at the judicial protection of fundamental rights in the European Union. He holds visiting positions at Sciences Po in Paris and Westminster University. He is now co-authoring the EU Common Foreign and Security Policy between Law and Geopolitics, forthcoming with Springer. Luigi, we are hearing more and more these days that we are witnessing a revolution in EU foreign and security policy because of the response to the crisis in Ukraine and the use of the peace facility to fund weapons and so on. Is this true at all? The floor is yours.
Thank you, Oana. A very good evening. I think it is not easy to speak after the words we have heard from Professor Petrov. I think the Russian invasion of Ukraine has shaken European conscience, and not only European conscience. Conceptually, the invasion calls into question the principle of self-determination. It is aimed at coercing Ukraine into a Russian sphere of influence, and militarily, land acquisition by conquest and the threat of nuclear war throws Europe back to the darkest hours of the 20th century. So it makes it necessary to rethink the basics of European security architecture. To answer your question from an European foreign security and defense perspective, I think that the hour of Europe has not yet come. The Hour of Europe is the one, to use the expression used by the then Luxembourg foreign minister Jacques Pos at the time of the breakup of Yugoslavia. Sure, the political unity shown by EU member states in the wake of the invasion is astonishing, if not total. Within the EU, the belief that Putin has, and I quote, crossed a red line and is wrong, end of quote, seems widely shared. The quotations are from no one else but Marine Le Pen, but similar language was used by other prominent politicians who were previously orbiting around Putin. In practice, however, actions have been more nuanced than the political statements and perhaps a rather superficial rhetoric by EU institutions evoke. As I shall try to explain, the EU has in fact decided to assist Ukraine indirectly when it comes to security and defense matters by financing the member states, not Kiev. And it did so through legal instruments which do not explicitly or implicitly increase the union's competencies. And most importantly, the EU does not bind its member states to transfer military equipment to Ukraine, arguably does not have the power to do so. So indeed, the main academic question as far as EU involvement in Ukraine is concerned are, I think, the following. What role can the EU play diplomatically in solving the conflict, or at least in mitigating its tragic consequences? Whether the choice to provide military equipment to Ukraine is wise, and finally, whether indeed we are witnessing a revolution in EU foreign policy. So I will say a few words on the EU's involvement in the peace process in the region, then I will discuss the transfer of military equipment with its desirability and whether it is revolutionary or not. So clearly EU's role in the region is best understood in the context of the interests of the various actors in the conflict. Considering that Putin's public justification for the invasion concerns, as we heard, NATO and the US administration and the promises of NATO, and considering the fact that the US administration has made it clear from even before the conflict, and it has maintained the position that it will not intervene militarily to avoid further escalation, the role of the EU at the outset was rather sidelined and, so to speak, I would say indirect. In fact, the EU as such was not directly involved in the previous peace process, which was instead overseen, among others, by the Organization for Security and Cooperation in Europe. I'm referring to the so-called Minsk process, which led to two agreements. The first Minsk agreement between Ukraine, Russia, and the People's Republics of Donetsk and of Luhansk on the 5th of September 2014, and then the second Minsk agreement of 12th of February 2015 between those parties plus Germany and France in the so-called Normandy format, that is, not by the EU directly. The assistance that the EU can provide to Ukraine is humanitarian in terms of financing, in terms of welcoming people fleeing the country, or it can be diplomatic, because the EU could either act as mediator or could find another party to act as mediator. On the diplomatic side, the EU's importance in bringing about peace is, I would say, sidelined by the military might of the United States and by the role of NATO as guarantor of hard security in Europe. When European countries did act as mediators in peace processes in the past, it was in fact member states, or indeed the leaders, rather than the EU who did act as mediator. I'm thinking about the trip of Sarkozy in the summer of 2008 to stop another invasion then in Georgia. That invasion of Georgia, by the way, which put Russia and Europe for the first time after the Cold War really on a trajectory of conflict which we now know was irreversible. The EU could be instrumental in securing another party to act as mediator. The EU High Representative has called on China to play that role. I think it is at best dubious whether China has the required impartiality. Turkey and today Israel have also put themselves as possible candidates to act as mediators. So the meeting that was mentioned earlier between Ukraine and Russia took place in Antalya, Turkey. And now turning to the other role of the EU in terms of financing and arming. So for the first time, the EU decided to finance the provision of military equipment designed to deliver lethal force. This was done through the European Peace Facility, which is an assistance mechanism of the Common Security and Defence Policy, part of the EU Common Foreign and Security Policy. The Council adopted the relevant decision, which is decision 338, the two relevant decisions 338 and 339 of 2022, adopted only 4 days after the beginning of the conflict on 28th of February 2022. To be clear, and contrary to what I have defined as the superficial rhetoric of EU institutions, the European Peace Facility does not finance Kiev, it finances member states, and there is a difference. And it also makes it debatable whether the actual transfer of weapons is attributable to member states or to the EU itself. The European Peace Facility is an instrument which finances operations having military or defense implications. The cost is borne by all member states, and this is an innovative feature of the European Peace Facility and its predecessor called the Athena mechanism, insofar as, contrary to the general rule of EU civilian missions or military operations, costs are not borne only by the participating member state or the participating third country. So there are, as I mentioned, two assistant measures. The first finances the provisions of lethal force. The second finances the provision of non-lethal equipment. The first of these decisions, interestingly, must comply with Common Position 944 of 2008, which allows member states to grant export license for the export of military equipment, provided that certain criteria are met. Now, I think those criteria are clearly met. The most relevant, in fact, of which is criterion 5, which states that the member states shall take into account, when deciding to grant export license for weapons, must take into account the potential effect of the military on their defense and security interests, as well as on the defense and security interests of friendly and allied countries. Now, is such decision to provide equipment designed to deliver lethal force wise? One might take the view that the EU response should better focus on trade, for example, through sanctions, and humanitarian assistance, rather than being involved more directly with military operations. The reason for that is threefold. First, the US position of not putting boots on the ground to avoid an escalation has merits, even though both Europeans and the US may soon need to reconsider this stance. Second, the respective roles of NATO and the EU suggest that the EU action should focus on humanitarian action and trade measures. And third, following from the second, the EU has, as such, virtually no expertise in the hard core of military matters. However, not only member states are not prohibited from assisting Ukraine under either EU law or the NATO treaty, arguably they are obliged to do so under EU and international law, provided that Russian actions are considered a breach of international law. Article 8, paragraph 1 of the Treaty on the European Union, read in conjunction with Article 3, paragraph 5 of the Treaty on the European Union, establishes that the EU shall share its values in the neighborhood, and these values include the respect for international law and the UN Charter. This is also contained in Article 1.2, letter C of the EU-Ukraine Association Agreement, even though that agreement does not contain a mutual defense clause. The mentioned measures are arguably also permitted under the EU-Russia Agreement of 1994, Article 99(1)(d), at least the harshest of the 2014 sanctions adopted against Russia were compatible with that agreement. Finally, under international law, Article 41 of Draft Articles on State Responsibility and Article 42 of Draft Articles on the Responsibility of International Organizations obliges countermeasures in case of grave breaches of international law. Finally, is the decision to provide lethal force revolutionary? To answer your initial question, my opinion is that it is not, because in fact the EU is not providing anything. The EU is financing its member states. The measures were adopted pursuant to powers that the EU has, and in some we are not witnessing acquisition of new EU competence. The decision permits member states to transfer weapons by financing that transfer, which is then organized and concretely implemented by each national competent authority, usually by national defense ministers. And this can be contrasted, for example, with the new generation EU as a COVID response, where the EU introduced centralized borrowing to fund recovering spending by member states. There is not such a step up in EU powers in this context. There are nonetheless relatively interesting legal issues concerning, for example, the bindingness of the decision. Hungary stated that it will not allow the transfer of weapons through its territory, contrary to what the decision mandates. The decision does not oblige the transfer of military equipment, and can more generally a member state refuse to comply with the decision. I think, considering that there is no mechanism for judicial enforcement, as the court does not have jurisdiction, the decision is best really understood as an expression of political unity. And this is why there has already been a possibly wise U-turn of Poland on the provision of fighter jets, for example, because the Polish Prime Minister said Poland is not a side in this war and called for NATO involvement instead. The decision of the EU to provide Ukraine with lethal force is nonetheless remarkable, as it is the first time that this has happened. To use the words of Professor Koudrakos, it is an action that moves away from the soft end of security, an area where CSDP, the Common Security and Defense Policy, has been carried out in relative comfort since its inception. And the decision to provide lethal force is also significant, as it casts a shadow on the characterization of the EU as a civilian power. But in the absence of the deployment of an EU military force, it is NATO's competence to provide the hard core of military security. So in conclusion, I think that the invasion of Ukraine will force a rebirth of European strategic thinking, and more generally, it will force us to rethink the security architecture in Europe as it emerged after World War II and as it evolved after the end of the Cold War. Thank you.
Thank you very much, Luigi, for this account. We were speaking about weapons and financing, and you were speaking about other maybe tools that could be used. We are going to turn now to these tools, and we will first going to hear from Professor Elaine Fahey, who is a Jean Monnet Chair of Law and Transatlantic Relations and Professor of Law at the Institute for the Study of European Law at the City Law School, City University of London. Now, Professor Fahey has taught and researched at the European University Institute in Florence, New York University, Keio University Law School in Japan, as well as at the University of Amsterdam, Trinity College Dublin, and practices as barrister. She researches the interface between EU law and global governance, trade, transatlantic relations, the EU's area of freedom, security, and justice, the study of law beyond the state. And her research was funded, among others, by the ESRC and the British Academy. She is having a forthcoming book titled The EU as a Global Digital Actor, which will be published with Heart. And that is why, thinking about more at the other fronts that we can fight this war on, spanning from cyber attacks, fake news to trade, I was wondering, Elaine, whether you could comment on that, as well as on the agreements maybe predating the war between the EU and Russia and Ukraine. Thank you.
Super, thank you very much, Oana, and it's very nice to get to share a panel with so many people, but such sobering thoughts to Roman in particular. I'm very grateful to him, amongst others, for being here. Can you see my screen okay? Yeah. Okay, so I'm going to speak about particularly the cyber sanctions ongoing, and one of the most curious things about the EU as a cyber security actor in recent times politically has been how it's been understood as very much a a law and resilience, multi-stakeholder approach. And it's, very much sanctions has been very much characterized by real timidity if they are actually part of the EU's foreign policy. But from a legal perspective, in the last few years before the Ukraine crisis, we've seen a rapid legalization, agentification, and even institutionalization of cybersecurity. But very much coming to your question also about trade, there's very weak synergies still between cybersecurity and trade, and the EU operates a very clumsy mix of the internal market and the CFSP as its firepower in cybersecurity. And up until this point, there's been quite a large amount of soft law in recent times. So you can say that obviously the EU is one of the most active user of restrictive measures in the world, and cyber sanctions have added to its weaponry of thematic regimes. And in this regard, the objectives being to deter and respond are very interesting when we put them under the microscope of the Ukraine crisis. But largely EU policy has been characterized by horizontalization. And that essentially has meant that there's more and more subjects and objects of cyber sanctions. And matters became, I've just finished a book project on this with cybersecurity as one chapter, and sanctions are quite a small part of my project so far. But the part that is interesting about sanctions recently was that individuals associated with Russia in particular were the subject of the first cyber sanctions in July 2020, including travel bans and asset freezes. And the EU has labeled this idea of cyber sanctions as part of the so-called cyber diplomacy toolbox, this lexicon it uses perhaps as to better regulation, this very EU idea of trying to operationalize something. And what we've witnessed in the last number of years is certainly the member states trying to show a coordinated response using the CFSP as to cyber matters. But increasingly we see in the CFSP much more judicialization, much more subjects and objects, and increasingly it's been very difficult to show proportionality, coherently justified EU responses, and of course that the targets enjoy full legal protection from the Court of Justice. And so those sanctions that I mentioned a moment ago last year were prolonged for even another year as to 8 individuals and 4 entities, including this asset freeze and travel ban, using the same lexicon of the diplomacy toolbox, that this is how the EU operates. It's a part of its foreign policy, this very organized framework that's the subject of this legalization. But of course, this cyber toolbox has been framed in such a way as a diplomatic response that the EU must be committed to resolving international disputes through peaceful and diplomatic needs. And also this very important and challenging question of a joint diplomatic response in the case of malicious cyber activity. So there's been much debate about the use of the EU solidarity clause, mutual defense, or what an armed attack is under public international law. And if you look at the range of sanctions mapping that the EU has as to what it has done in the last few years, and I know my colleagues are going to speak about this further, I'm just speaking just right now about one tiny aspect of this massive plethora of sanctions in so many levels as to so many individuals. And I think as I prepared these slides, the numbers of individual sanctions related to 600 and something, I think that number was 800 and something just this morning, if I'm not correct. I'm sure it's changed again now. But one of the foremost authorities in the world on Russia is, of course, the British woman, Dr. Fiona Hill, the Trump advisor who resigned very quickly and has said just in the last few days, one of the key things to understanding this war is about fighting misinformation from the Putin regime with information where you can find it, and that Putin is carefully working to distort the past and manipulate the current narrative. And this digital war has been a hallmark of the last few weeks, seeing massive exercises in digital wiping of Ukraine computers, massive attacks upon Ukraine by Russian entities. And so the disinformation war has been very much to before the tanks being actually on the ground. Now, if we look at what is EU law and disinformation, well, one of the most interesting pieces of law about all of this is in fact the Digital Services Act. So along with the Digital Markets Act, some of the most complex legislation the EU has adopted or is looking to adopt in recent times as part of the digital strategy. But one thing that is really simple about the DSA, and there's nothing simple about it, is that disinformation has a very straightforward approach that a tech company has to just remove it or face a fine. And it's accompanied alongside with a code of practice. And this idea of soft law bolstering EU actions in this field is widespread. Codes of practice, fact checkers and media observatories, action plans, communication. The EU has adopted, a very large-scale approach as to disinformation, but largely couched in soft law until recent times. And the European Parliament, just a few weeks ago, in its very interesting committee, a special committee has been set up on foreign interference in democratic processes in the EU, including disinformation, published a report. And there's 57 mentions of Russia in this report. And I think it's very important to say that it's a focus upon the democratic process. But you'll see as part of that report, the European Parliament has recommended, this is just a few weeks ago, that the EU would build a sanctions regime against disinformation. And so just, one of the first things in the famous von der Leyen speech that has launched the EU's wave of sanctions is to ban the Kremlin's so-called media machine, including Russia Today and Sputnik, so that they would no longer be able to spread their lies and sow division in the EU. And you'll see a day later, the Council's announcement mentions to urgently suspend the broadcasting activities of Sputnik and Radio Today to conduct disinformation and information manipulation. And this other key phrase we see a lot, the systemic international campaign of disinformation, information manipulation, and the distortion of facts. So there are two key measures as to cyber sanctions and disinformation. The first is Council Regulation 2022-350, which is based upon Article 215 TFEU. And you'll see in the preamble, which are not legally binding clauses, but very interesting nonetheless, mentioning disinformation, foreign interference, and the systemic international campaign of media manipulation. But there's also references here to proportionality in the paragraph 10 as to the Charter of Fundamental Rights, and Article 11, and also interestingly in paragraph 11 as to the freedom to conduct a business and the right to property. And apologies for my scrawled red pen there. If you haven't lost your eyesight in the last 2 years, you might be able to see it somewhat. And then the other really interesting, significant legal provision as to this is adopted around the same time, the Council decision CFSP 2022-351 of the same day, based upon Article 29 TFU, also mentioning disinformation and international campaigns of media manipulation, and again referencing the Charter of Fundamental Rights as kind of quid pro quo, but also a slightly different formulation here in paragraph 11, that those measures don't prevent media outlets from carrying out other activities other than broadcasting, such as research or interviews, which I think is a very interesting formulation. And you'll see that the key substance of the provision is about suspending broadcasting licenses. And then the bottom there of the paragraph, it's prohibited to circumvent prohibitions in the regulations. And you'll see the entities are listed, the annex that are listed as Russia Today and Sputnik. So it's very specific in the manner in which it's targeted, and also in this as to the suspension of their licenses. Just wearing my transatlantic hat, what's happening across the Atlantic is quite interesting, because slightly after the EU, you'll see the State Department has been publishing a lot on the agreed targeting. So we're seeing transatlantic alliances in foreign policy of a kind not witnessed in the last number of months. Certainly in transatlantic relations, there have been lots of lows built up as highs. And disinformation here is also mentioned, but when we look at the detail of the blocking sanctions, it's a very different list of the designation of Russian entities and individuals. In fact, it looks like an entirely different array, but I'm still working on this and subject to being contradicted or assisted by anybody in the audience who's working on this. And luckily, as I'm in the UK, I've had access to Russian media because the UK was much slower than the EU in this regard. I just wanted to say one very brief thing as to Oana's question there about, one of the interesting things about the work of Roman and others about the Ukraine agreement was, as we were told in the Brexit referendum, the Ukraine agreement is one of the closest one can be to the EU outside of being in the EU, a new type of integration without membership. And even though it's a very modern agreement, you'd struggle to see anything interesting in it on security. I would say maybe Title II, very limited provisions for envisaging the type of actions of the EU if you're to look for it there. And if you're to contrast this, this is the text of the Brexit agreement, the Trade and Cooperation Agreement, there's a detailed set of articles, even in a very thin agreement with the UK, with all of the malaise there is, and currently in EU-UK relations, still a remarkable institutionalization of cooperation, dialogue, participation, and so on. So I think, just very briefly to conclude, that there's some really interesting questions about how the EU's measures have been implemented. Twitter and YouTube, there's lots of critique on tech sites about how the very shaky start to all of this. Very interesting questions about proportionality and about litigating Article 11, about the broadcasting interview rights. I think there's lots of very awkward precedents that have been set before the Court of Justice, but I'm happy to answer anything in questions, and I'm not particularly looking forward to having to slip in 5,000 words on cyber sanctions into my book, but here is a shameless plug to finish upon it. But thank you very much.
Thank you very much, Elaine. Now we're going to turn to another set of sanctions, which are the economic sanctions. And I am going to give the floor to Professor Takis Tridimas, who is my colleague here at King's College London. Takis is a professor of European Union law and co-director of the Centre of European Law at King's. He's a leading author of European Union law, and his work as a barrister covers the whole spectrum of EU law and the European Convention of Human Rights. He has been doing valuable research on Brexit and its consequences, and is currently co-editing a number of writing a number of volumes, to name, for instance, the Oxford Principles of European Union Law with Oxford University Press. Takis has advised EU and national institutions and is one of the most frequently quoted academic authors by the Advocates General of the Court of Justice and on matters of EU law by English courts. He has been handling cases before the Supreme Court of the UK, the European Court of Justice, the EU General Court, and the European Court of Human Rights. Takis has been involved in cases on economic sanctions as well as EU external relations, among others, which brings us to the topic of the day. Takis, could you comment on the implementation and effectiveness of the economic sanctions against Russia? Thank you.
Thank you very much, Oana, and thanks to all participants. And can I also take this opportunity to pay tribute to Professor Petrov, to Roman, for joining us and really honoring us under extremely difficult conditions. And of course, I reiterate that we are all here to support in any way that we can. Now, there is no doubt that the Russian invasion of Ukraine is the most serious war in Europe since the Second World War, and in geopolitical terms, it is a game changer. And although the European Union has been bedeviled by successive crises in the last 15 years, including, of course, the Eurozone crisis, migration, Brexit, COVID, I think the Russian invasion is qualitatively different. And it is qualitatively different for a number of reasons. First, it is a humanitarian disaster. Secondly, it is a manifest breach of fundamental rules of international law, as Luigi very well explained. Thirdly, it poses a security threat to all European states, and for some of them, it is perceived as posing even an existentialist threat. And again, I think there is no doubt that it unsettles the political underpinnings of the liberal order as it was established since the fall of the Berlin Wall. So it calls for rewriting the rule book. It is in some respects a war about Europe's soul and values. It is the antithesis of Article 2 of the Treaty on European Union. And as the war unravels, and the EU was caught by surprise, the aphorism of the Belgian foreign minister Eyskens back in 1991, that Europe is an economic giant, a political dwarf, and a military worm, I think reverberates. I don't necessarily agree with that aphorism, but I think it is a poignant time to revisit it. So I think the war may well change yet again the integration paradigm. It may change the security architecture, as Luigi said, and I think it tests solidarity at European Union level in a way that it has not been tested before. Now, on economic sanctions, the imposition of sanctions, of course, by the European Union began to develop, especially in the form of smart sanctions against individuals in the aftermath of September 11. They have since been used as the heavy hand of diplomacy and in many respects really as a substitute for the lack of military power against individuals, against countries, against regimes, including suspected terrorists, Iran, Syria, and of course, Russia. The sanctions of the European Union against Russia were first introduced in 2014 in response to the annexation of Crimea. And following the invasion of Ukraine, the Union introduced further measures, imposing essentially the most extensive sanctions that have ever been imposed by European Union law. It has adopted chronologically 4 packages. We are now actually on the 5th because things change so quickly. The first set came on the 23rd of February, then a second one on the 25th. It was then followed by further sanctions on the 28th of February and the 2nd of March, and further sanctions were imposed yesterday. And I think the EU itself classifies them, provides a taxonomy of the sanctions, which I think is useful to follow. Some of them have the form of diplomatic measures by cutting ties with Russia in a host of diplomatic and international fora. Secondly, individual restrictive measures. So these take the form of asset freezes and travel restrictions. Thirdly, there are restrictions on economic relations with Crimea and Sevastopol, and with the non-governmental and the areas of Donetsk and Luhansk, which are not controlled by government forces. There are sanctions on media that Elaine explained again very well, restrictions on economic cooperation and further economic sanctions. Similar sanctions, or at least some of them, have also been imposed against Belarus. So are they wise? Is it wise for the EU to impose these economic sanctions? I think it is difficult to say that they are not wise. This is the EU is primarily an economic organization. This is what it can do, and this is what it does. Will they be effective? I think the jury is out. I don't think they're going to have an immediate effect. Traditionally, sanctions fall short of facilitating, of bringing about the change of behavior that they are intended to bring about. So there's a very vibrant debate in politics and also in academic discourse about the effectiveness of sanctions. One will have to wait and see. I think it is correct to say that these sanctions are unprecedented. They have already had an effect on Russia. The ruble has lost 33% almost of its value. There are sanctions on all sorts of imports. Now, I understand that only 1/3 of Russian imports accounts for consumer goods. The rest are capital goods or intermediate goods that are used for the production or the manufacturing of other products. It appears from the international press that the aviation industry may be particularly affected as a result of controls in the exportation of various components. There is, of course, the elephant in the room, and this is the energy supply from Russia. This has not overall been affected. The energy supply refers mostly to gas, not to oil. I think Europe is a lot more dependent on Russian gas than it is on Russian oil. And there is no doubt that sanctions will hurt not only Russia, but also those that impose them on Russia. The expulsion of Russian banks from the SWIFT network, I think that is of major importance, because essentially it cuts out Russia from the international banking system. It makes payments much more difficult. And I think long gone are the days where you could pay for energy, you could pay for petrol by, or you could pay for other goods by carrying suitcases full of dollar banknotes over the border. So I think they will bite. I think it is not as easy for Russia to seek alternative markets in China. And I think that's for many reasons, not least geographical reasons. It's very far away. So there is no doubt that there is going to be a readjustment on both sides. The sanctions appear to me to be essential. Whether they're going to be effective, I think remains to be seen. Now, the key measure in legal terms, the key measure in all this is a council decision going back to 2014, council decision 145 of 2014. This is a CFSP decision, and it concerns the restrictive measures in relation to actions undermining or threatening the territorial integrity, independence and sovereignty of Ukraine. The form and legal nature of sanctions, I think, is familiar to most of the audience, so I don't think I need to go into any great detail on that. They are not criminal measures, but they are invariably, or at least almost invariably, supported by criminal prohibitions at the national level. And they have, of course, this peculiarity because on the one hand, they are measures of general application. The typical formulation, which is included in the Council decision 145 of 2014, is that all funds and economic resources that belong to the people who are listed in the annex are frozen, and that no funds may be made available directly or indirectly to those persons. So it is a direction, it's a stipulation which is addressed to the world at large. As far as third parties are concerned, not those on whom they're imposed, they affect particularly financial institutions, banks, insurance companies, and they do have a highly disruptive effect on commercial life. I think that became evident, especially in the imposition of sanctions against Iran. Although they're not criminal in nature, they do have a highly restrictive effect on those on whom they are imposed. Lord Justice Sedgley referred to those who are sanctioned as prisoners of the state. And even though it is not now the time to think about the rights of those parties, I think it is always important to remind ourselves what distinguishes the EU from Russia: the commitment to the rule of law, the commitment to judicial protection, the commitment to the values of Article 2. I think inevitably there are going to be issues that arise on both sides of the Atlantic. There are many directives, for example, from US authorities addressed to financial institutions. It is not always clear how these directives interact with existing, with previous sanctions. It is not clear to what extent they prohibit, for example, the purchase of the ruble in secondary markets. So I think inevitably we're going to have litigation. In relation to the European Union, perhaps I can finish by very brief comments on three recent judgments by the European Court of Justice. One of them is the Venezuela case, Venezuela and Council. I think this is an important case because essentially what the court decided was that a third country can bring an action under Article 230, paragraph 4 of the TFEU. It is a legal person, and it can do that irrespective of whether it acts as an imperium or whether it acts as a commercial actor. There is a fundamental right to judicial protection, the court says, which does not depend on reciprocity. I think that is an important judgment, which follows the approach that the court followed, for example, in Rosneft and previous cases, emphasizing the right to judicial review. And along the same lines, we had a more recent case, the Bank Refa Kargaran case, decided in 2020, where the Court of Justice comes to the conclusion that damages are available, an action in damages is available for CFSP measures, for loss arising as a result of CFSP measures, that cannot be used for breach of the requirement to give reasons, because this is a procedural requirement, but it can be used for substantive violations, which in turn raises the issue of the distinction between the requirement to give reasons, which is a procedural requirement, and the requirement to give good reasons, which is a substantive requirement. The threshold is very high for an action to succeed. All I would say in this context is this, that when the EU first started using economic sanctions back in early 2000s, the rate of success against those sanctions following the Caddy case was very high. It was one of these areas where the rate of successful judicial reviews in EU law was a lot higher than the average rate. We have moved on since then. I think the EU is a lot more careful in justifying the imposition of sanctions, and I think the court provides a measure of good vigilance. In this context, I think it's worth mentioning a fairly recent case, the Rothenberg case. This is a successful challenge to the imposition of sanctions against a person who was sanctioned on the ground of being very close to President Putin. And the General Court found essentially that the Council had not given adequate reasons. There were contradictions, inconsistencies in the reasoning of the Council. The Council considered that he took the decision on the basis that he was a shareholder of a company, but no proof was offered for that. But there is also another statement there. The court appears to suggest that the fact that someone might have been an associate of a government or Mr. Putin in the past is not necessarily good reason to sanction that person. There has to be some kind of connection with the undesirable conduct, in this case, the invasion of Ukraine. So the case law, I think, is the standard of review that the General Court and the European Court of Justice employ is high. I think there may well be a distinction between imposing sanctions on individuals, imposing sanctions on states, but I think that is something that we would need to continue monitoring. So in a nutshell, the sanctions have been unprecedented, very wide-ranging. It remains to be seen how effective they are. It remains to be seen what effect they will have on the EU. And I think by way of conclusion, we would also, again, it's early days, but I think it is important to consider the aftermath of the Ukraine crisis. It is an unprecedented crisis. It is extremely sad. And it is, as I said, the antithesis of Article 2 of the European Union, everything that the EU stands for, and indeed anything that international law stands for. But we would need to consider the day after. What would be how can Russia be accommodated following the crisis? I think because that is a key issue for the strategic interests of Europe. Thank you very much.
Thank you very much, Takis. Now we are going to turn to a different European law, because we are embracing a very wide definition of European Union law. And we're turning to Professor Kanstantsin Dzetsiarou, who is professor in human rights law at the Liverpool Law School. Kanstantsin and I started our academic careers together at University College Dublin in very peaceful times, who seem like a century ago. He has taught ever since at Surrey, cooperated with international, intergovernmental and non-governmental organizations as an expert in international and European human rights law. His research interests spread between interpretation of the European Convention of Human Rights, reform of the European Court of Human Rights, administration of international justice, comparative and constitutional law. Kanstantsin has written on the role of human rights in relation to the 2020-2021 Belarusian protests, and currently in relation to the war in Ukraine. His recent book with Cambridge University Press discusses whether the European Court of Human Rights can shape the European public order. And this is precisely my question today, Kanstantsin. In the current context of war, can the Council of Europe, the Court of Human Rights, or human rights law be of any help? Thank you.
Thank you, Oana. Thank you for organizing this extremely important and interesting debate. Thank you, colleagues. Before I go and try to very quickly answer Oana's question, I have to declare my bias. I'm originally from Belarus, and it absolutely hurts me that the territory of my country is used by the Putin's regime to attack our neighbor. And I have to say that it absolutely hurts that I'm absolutely sure that the vast majority of Belarusian people, they don't support this war. And I, like many of my compatriots, have plenty of friends and relatives in Ukraine. My mom, for example, studied in Kharkiv, which is one of the biggest university center in Ukraine and which is under constant shelling at the moment. So having this bias in mind, I will try to present my view on what the Council of Europe did or didn't do in relation to the Russian participation in this organization. And unlike the European Union, in which neither Russia nor Ukraine are the members, the Council of Europe is the organization in which both countries are the member states. Moreover, they are the member states to the European. They are contracting parties to the European Convention on Human Rights, and they are expected to comply with Article 3 of the Statutes of the Council of Europe, which declares the values of the Council of Europe, which include human rights, democracy, and rule of law. And I guess that none of these values are evident from the perspective of in the actions, especially recent actions of the Russian Federation. But we shouldn't forget that these military engagements of Russia it didn't begin on the 24th of February this year. We shouldn't forget that Russia occupied Crimea in 2014 and initiated the crisis in Donetsk and Luhansk. We also should remember the crisis, the military confrontation in 2008 in Georgia, etc., etc. So basically, there is a very clear pattern in the Russian behavior in relation to solving some ambitions of the Russian regime through military means. And I've been argued for years that this behavior of Russia should lead to suspension of the rights to representation of the Russian Federation in the Council of Europe. Unfortunately, it only has happened on the 25th of February 2022, when effectively a full-scale war started in Ukraine. So what are the, first of all, I will very briefly look into what happened after the war began from the Council of Europe perspective, and then I will briefly consider what consequences this will have to Russia, to Ukraine, and more generally to the regime of human rights in Europe. So what exactly happened on the 25th of February? On the 25th of February, the Committee of Ministers of the Council of Europe, this is one of the statutory bodies of the Council of Europe, voted to suspend the right of representation under Article 8 of the Statute of the Council of Europe. That effectively, although the Committee of Ministers was very clear to say that it's just a suspension, it's not, we are not going to expel Russia just now. If you read Article 8 and 7 of the statute, it is clear that suspension, it is the last warning, and it's almost an invitation to withdraw. And the Committee of Ministers absolutely clearly understood that this will mean that Russia will withdraw, because on the number of occasions, the Russian Minister of Foreign Affairs was saying that as soon as there is a hint of a possibility that we are suspended, we will go. Now, so that didn't, it was stopping the Committee of Ministers and the Parliamentary Assembly from more proactive actions in the past, but obviously it was the red line, as was already mentioned, that could not be overlooked this time. So, okay, like the Committee of Ministers voted, the voting was interesting. It was a secret vote, of course, but as all secret becomes non-secret sooner or later, the results of the voting was leaked to the press pretty soon. There were only two countries which voted against suspension, and of course, if I had a classroom, we would definitely play a guess game of who that might be, and obviously one of them is very obvious, was the Russian Federation, and the second one was Armenia. A couple of countries abstained, either not participated in the meeting at all, or decided not to vote. So then the voting happened, and the decision says that the Russian judge continues to work in the European Court of Human Rights, and the applications can come to the European Court of Human Rights. Now, since then, the Russian government was very quiet. I'm sure that this issue of the Council of Europe was not very high on their priority list in terms of diplomatic landslide that was going, and rightly so, in their direction. However, only this morning, the Russian Ministry of Foreign Affairs declared that they are, and I'm quoting, translating, they are not going to participate in the Council of Europe any longer. What that means, we don't know, right? But I would interpret it as they are going to withdraw. Well, a more liberal interpretation of this might be that they accept that they are suspended and they are not going, they will continue being in this limbo. But I don't think that the Council of Europe itself will allow this situation to last. So effectively, there are three consequences of this decision of the Committee of Ministers. First, Russia withdraws all their military from Ukraine and go back. So then this suspension will be lifted probably. The other one, then Russia will withdraw from the Council of Europe. And the third one, Russia will be expelled. There will be another meeting, extraordinary meeting of the Parliamentary Assembly of the Council of Europe on Monday and Tuesday. And obviously this is the only question to discuss. Now, I have to say that triggering of Article 8 is the first time in history of the Council of Europe when that happened. There was a possibility of this happening in the 60s against Greece, but Greece was quick to withdraw before that happened. Greece returned 4 years later. Whether Russia will ever be able to return, that's an open question at the moment. Very briefly, I promised myself that I will finish at 7 o'clock, but very briefly, what that means for Russia and why the Council of Europe was so reluctant. I think there are 2.5 main reasons why that was the case. First, well, the Council of Europe was saying that Council is one of those venues, diplomatic venues, where the negotiations are possible with Russia. Well, we can see that it doesn't really work like that, to be honest with you. The second one, and second is, I think, one of the most important arguments, is the access of the population of the people under the jurisdiction of Russia to the European Court of Human Rights. And I agree, this is very valuable avenue for people to fight injustice, and sometimes the Strasbourg Court becomes the only court for Russian people in certain areas. However, and the Strasbourg Court was successful in certain areas under certain circumstances, but globally speaking, the European Court of Human Rights is unable to prevent the growth of illiberal democracy, and Russia is one of the greatest examples of that, and it cannot prevent mass-scale human rights violations. And therefore, when we balancing these two things, when you know, like access to the Strasbourg Court, as opposed to having Russia in the family of states pretending to share the values of human rights, democracy and the rule of law, I think that when this happens, a situation like this happens, I think the latter should prevail. So it means that as soon as Russia withdraws, and I think it will happen fairly soon, the Russian citizens will not be able to apply to the European Court of Human Rights. A huge backlog of cases that is still pending in the European Court of Human Rights will still be there. I would like to remind you that there are, I think, 11 applications, interstate applications of Ukraine against Russia pending before the court. There is an application of the Netherlands against Russia in relation to downing of the MH12 aircrafts, also pending before the European Court of Human Rights. What's going to happen with these cases are difficult to predict, to be honest with you, because for the court you need to have a collaborating, more or less at least collaborating respondent state to deliver a judgment. And when we have a state which is not party to the convention any longer, it is difficult to know what is the reason to deliver this judgment. Just for the sake of delivering that, maybe the court might have to prioritize other things. I don't want to predict what the court will decide in this case, but this is an interesting issue to have a look. Right, and so we don't know what's going to happen with these particular cases that are pending now, but it is obviously a very, very bad news for civil society in Russia. And what some people might even argue that this is punishing those who are not particularly guilty of this conflict, etc., etc. So it is a difficult dilemma that the Council of Europe had to do. I think that the decision that they made is absolutely correct. What more can they do? I don't think much. To be honest with you, the scope of punishments or sanctions of the Council of Europe is very limited. And this expelling and suspension of membership is the sanction of last resort. After the country is not the member, you can hardly do anything. And this was one of the most painful aspects of the Belarusian crisis in 2020. The Council of Europe was saying, what can we do? They are not the member state. So the Russians potentially can participate in some of the treaties that are concluded under the auspices of the Council of Europe. For example, Belarus is a member of Greta and other organizations, the Venice Commission, that might also be under issue there. But generally, the Council of Europe is quite weak in terms of the sanctions that it can apply after the country is gone. And even when the country is not gone, the whole system is designed for like-minded countries that are willing to collaborate. If a country does not want to collaborate, the Council of Europe has very limited toolkit at its disposal. And this is the reason for the Council of Europe really to rethink itself. Compliance is a problem there. Thank you very much, and thank you, Oana. We'll be happy to answer your questions.
Thank you very much, Kanstantsin. Now the speakers generously agreed to some more minutes of their time to answer some of the questions. There are some questions on the chat I see. I'll probably start first with a question that is specifically directed at Roman, but you can jump in as well. Is there a possibility of there being a government of Ukraine in exile at the end of this conflict? And how exactly would such an entity be treated by the European Union? Could such a government nation approach to the European Union perhaps join it?
Thank you. Thank you very much. It's a highly provocative and engaging question. I know, of course, I never thought about it. But to answer the question how it's formulated, I would like to say that my answer now would be completely different than it could have been 2 weeks before. Today is actually exactly 2 weeks from the start of the conflict. Because now I can firmly say that there is no way and there is no possibility for the whole territory of Ukraine to be subjugated and occupied. I would like to remind to our audience that even now, taking into account that the one regional center is being occupied, none of the Ukrainian cities and towns have accepted voluntary authority of the occupying force. Even today, the city of Kherson, which is a regional center in the south, still, regardless being completely under occupation, every day hosts demonstrations and public display of Ukrainian flag. I think it's extremely remarkable, taking into account what division was a division of nation and languages took place in Ukraine just 8 years ago, when country was very much divided over many issues, including the language. So even if Russia, and I see a current report that it already started using unconventional, prohibited lethal weapons like vacuum bombs and some other strange, horrible stuff is on its way, unfortunately. Still, resistance is remarkable. And in the worst case scenario, the government, if Kyiv is going to be taken by military means and total devastation, is likely to move to the west. And being here in Lviv, I must admit, I don't see any option. It just would cost Russia too much to occupy the whole territory. It just doesn't make any sense to take devastated territory and completely rebellious population. Therefore, I don't consider even this possibility. In the worst case scenario, Ukraine, of course, could lose significant chunk of its territory. However, the western part is most likely to resist and remain, and this part of Ukraine could be successor of, and it will be considered as a Ukraine which was a party to the EU-Ukraine Association Agreement and to other important international obligations. Another question might arise, what Russia would do with occupied territories. In this case, of course, and it's already, as leaked information follows, Russia is keen to appoint its proxy prime minister or government completely under control. And therefore, if Russia occupies significant territory, it might introduce its temporary administration, probably represented by pro-Russian Ukrainian politicians. However, in my opinion, most likely scenario is to set up another non-recognized entities. I just can mention that recently I completed research in a book called Non-Recognized Entities in European International Law, and most likely such a territory could be, because there is already well-established experience earned by the Russian authorities to set up non-recognized entities. So visibly, it's going to have all features of the state, but I doubt anyone is going to recognize such a territory. And even if but when we answer a question when our government moves to exile, or what it would imply, I think another question, legal question, whether government in exile could be considered as a part of the accession process, let's say. And here I would say that I doubt, because the entire philosophy and objective of the accession process, it's about a certain territory to be able to be part of the EU internal market, and we all know the Copenhagen criteria. So I see problems there. I don't think that government in exile can be part of the accession process for many reasons, mainly economical, political, and spirit of the Copenhagen criteria. However, as I said before, I don't believe that it will happen. And unfortunately, also I would like to mention that even if the Russian forces move far west, the level of humanitarian catastrophe, victims, and devastation would leave no choice, unfortunately, for the EU and NATO if they really want to keep spirit of Article 2 and values, but to intervene. I just don't see any other option. Sorry if my answer was too long.
Not at all. I'm going to turn to some, but we have quite a lot of questions about Council of Europe and human rights. And I know that Kanstantsin is probably on his way out of the office. So there is one question which is directed to Kanstantsin and Roman, I think. How do you feel regarding the probable withdrawal of Russia from the Council of Europe, Roman? Are you fearing that the Russian government and army become even more determined, violent, and harmful, both in the context of the invasion, but also in the Russian internal context? And for Konstantin, taking into account the way the Russian Constitutional Court in 2016 has interpreted the possibility of non-enforcement of European Court of Human Rights judgments, if they are based on such an interpretation of the convention, which contradicts the Russian constitution, will Russia's withdrawal from the Council of Europe affect the practical aspect of enforcement of these judgments? Maybe we start with Konstantin, jumping to Roman, and then I'll have some question for all.
Thanks very much. I also wanted to comment on the first question, but obviously Roman knows better the situation on the ground. I wouldn't overestimate the impact of the Council of Europe on the day-by-day activities of the Russian government. I don't think that, to be honest with you, I don't think that withdrawal from the Committee of from the Council of Europe will have a major impact on the way that hostilities are undergoing. I don't see how the Council of Europe was instrumental in preventing it. And although, again, although the Council of Europe is an excellent organization, but it only works properly when the contracting parties or the member states, they are happy to participate. If they don't, the Council of Europe has very little leverage. So that is my answer to this question. There was a small comment whether Russia has withdrawn today. No, Russia hasn't withdrawn today. It hasn't been, well, it was flagged that it might withdraw, but this process hasn't ended yet. But formally it will be done pretty soon, I think. And finally, in relation to the question about the Russian Constitutional Court, we need to understand if Russia goes, they will not execute any judgments, irrespectively of whether it is going to be delivered now, later, or anytime. So it is, I don't see how the Committee of Ministers can influence a country which is outside. So we need to understand, as soon as Russia leaves, even those judgments and the execution of those judgments which is pending, this will not have any impact on the Russian legal system. So the decision of the Russian Constitutional Court of 15 and then 16, etc., is of very little relevance to the fact that there will be no judgment that will be actually enforced, as far as I can see. Maybe there will be something different in practice. Now, but like this procedure introduced by the Russian Constitutional Court, it's very targeted. It's effectively, it was targeted in relation to only one case, which is case of Yukos versus the Russian Federation, and that's it. So I wouldn't really see this particular judgment of the Russian Constitutional Court as an important milestone. And now the Russians adopted new amendments of their constitution, so this is all a little bit less relevant to the situation. Thank you very much, and I'm sorry that I will have to leave in 5 minutes.
Thank you, Roman. Yeah.
Yes, and of course I fully share Konstantin's views and his suggestions, and probably it's wrong. Maybe not all my country fellows share my opinion, but I'm also not quite happy about Russia leaving the Council of Europe for reasons what Konstantin mentioned. Unfortunately, it must be underlined, emphasized that it has been already quite a long executed strategy on behalf of the Russian government. We all remember these constitutional amendments. We also must recall these repeated calls and speeches, historic lectures on behalf of President Putin on the necessity to revise the international legal and international system order. And it looks like it was a more or less conscious step, and also calls on behalf of Medvedev to introduce the death penalty. So it's a kind of part of a consistent strategy, unfortunately, very negative strategy. And Russia certainly consciously takes itself into isolation and repression within the country. It's a very bad sign and message to the Russian liberal elite, and what as far as I know, in masses, middle class and the liberal intelligentsia live in the country. So so it poses a whole question about the effectiveness of sanctions, because it's really difficult to see what the EU and US and NATO are going to do when the whole arsenal of sanctions is going to be executed. I presume with fear that it has been already calculated, and the step was conscious on behalf of the Russian government. They consciously took this choice to resist the sanctions and to plunge and plummet into complete self-isolation with the hope to be supported by other superpowers. Thank you.
Thank you, Roman. So now I'm going to probably, if you agree, to go to up to 30, because we have quite a lot of questions. I'll have one question now for Takis, Elaine, and Luigi. Professor Alan Dashwood, if Ukraine is compelled under extreme duress to agree to an unfavorable settlement, should or could EU sanctions against Russia be maintained? And also there is another question that is targeting mostly the proportionality in times of war. What is proportionality? How can we assess that the sanctions against individuals, the asset freezes and so on are proportionate, given that we have this unprecedented situation here? So maybe I'll take in the order, in the reverse order that people spoke. So starting with Takis.
Thank you very much. I'm so sorry. Thank you very much. All the questions are extremely interesting. If I could start with Professor Dashwood's question. The question is this: if there is an unfavorable settlement, in extremis, a very bad settlement for Ukraine, can and should the EU maintain its sanctions? I would say the EU can maintain the sanctions. I don't think that a settlement, irrespective of its content, is in itself something that would render the continuation of sanctions illegal. I think the EU has a lot of discretion. Really, almost all of the cases decided by the court have to do with process rights rather than substance. With some exceptions, but none of them have to do really with the wider policy issue. How does the EU choose which countries or which individuals to sanction? So I don't think there will be a legal incompatibility. Should the EU continue them? Again, I think it depends on the circumstances, but it is not clear to me that an unfavorable settlement that runs against the values and the interests of the EU would be a good reason for the EU to stop the sanctions. On the issue of proportionality, well, I don't want to get into too much detail. I mean, as the decision of 2014 stands at the moment, it requires certain criteria for the imposition of sanctions. and one needs to be actively supporting, and there was another question on this, or one needs to be benefiting from the sanctions. I think here we go to the use of presumptions or indicia, which the court has accepted in the past. So in a country which is highly authoritarian, a person who enjoys a prominent position in business is presumed to be benefiting from the government. To me, that's fine. It does not offend my sense of justice to reason on that basis. And as I said earlier, it is one thing to question process. It is another thing to question the criteria for including someone. But again, we'll have to wait and see. I'm sure there will be more litigation. Thank you.
Elaine?
Just very briefly on the question of proportionality and effectiveness, I think this is a very different issue as to cyber sanctions, given the ingenuity and technology issues about application. I think we're going to see, especially in Twitter, and the capacity to circumvent here being really a question of difficulty as to how the wording of the EU's measures the elasticity thereof. And I think it's going to be a very difficult one for the EU to, when there's such a gap, or what looks like such a gap between the transatlantic dimension to this and how media operators will function. But I think also this question of the legitimacy of the carrying out research and interviewing and so on, the kind of softer indirect dissemination or disinformation through dissemination, as it were, will become possibly a very interesting issue here. But I think that technology itself has shown the capacity of the bots and so on to just the sheer use of technology in vast numbers. And so here we're looking at particular channels and media, I think, is a very different kind of way of looking at this. So it's an extraordinarily large step for the EU to take, and I think it'll be interesting to see how it gets policed. But I think it's quite a different question to the other side.
Thank you, Elaine. Luigi?
But perhaps if I can comment briefly on the question of Professor Dashwood, I think that a treaty concluded under extreme duress would be possibly, would certainly be a violation of international law. It's a violation of Article 52 of the Vienna Convention on the Law of Treaties. It's possibly also the result of a violation of jus cogens. So the European Union arguably should maintain sanctions against Russia, whether or not it is bound by Article 52 of the Vienna Convention on the Law of Treaties. But I think that an interesting question is, at this point, what would be an international settlement between Ukraine and Russia which is not under extreme duress? So at what point is an agreement, any agreement concluded by Ukraine, the result of a genuine non-coercive will of the country?
Good point, Luigi. Now, turning to Roman, Professor Schick is asking about the, I suppose, the trials and tribulations of the EU-Ukraine relationship. First of all, why didn't the Ukraine apply for EU membership around the Orange Revolution in the year 2000? And then how was the agreement basically negotiated, the EU-associated agreement, whether the process was not delayed by the forces in power as they be. Roman?
Yeah, I'll try to. It's a very complicated issue and topic to discuss in so limited time, but just briefly, Ukraine, I would like to remind that before the EU-Ukraine Association Agreement entered into force, Ukraine had no legal right to apply because it was not, as I mentioned, considered officially, formally by the EU as a European state, and we all remember that according to the Treaty of the European Union, only European state can formally launch an application. So the door really was opened since after the agreement was entered into force in 2014, political part. Also, the Ukraine has been consistent always about its willingness to apply to get a formal invitation or candidate country status, and there were certain peaks and downs. Peaks, of course, first peak came after a period after the Orange Revolution 2004. At that time, the EU offered a consolation pie, which was called the Eastern Partnership, which is still in place. And it worked out for some time. So Ukraine never was happy about this arrangement, but the agreement itself, association agreement, was a good carrot. Once it was negotiated, I would like to remind, by the Yanukovych government. Therefore, we must understand and comprehend that its scope, its structure reflects Ukraine at that time, how it was, and it corresponded to interests of Ukrainian business elites at that time, and only pressure, high pressure on behalf of Russia, of course, prevented Yanukovych to sign, and it was the cause of the revolution of dignity. It was another peak, and at that time, Ukraine was busy with the first war and actually entering the agreement into force. And I would like to remind that even procedure to enter into force, to ratify, took about 3 years, mainly due to the negative referendum in the Netherlands. So it was not an easy process at all. So, there were ups and downs, and Ukraine, it's the first actually opportunity what Ukraine used to apply for the membership, which took place a couple of days ago in the end of February.
Thank you very much. Like, if I can push it just for 2 more minutes, very, very short thoughts, last thought from each and every one of you. There is one question that can get us going, which is, would this split Europe further or bring it closer together? But any other final thoughts are absolutely welcome. Starting with Luigi.
I don't think that we have the instruments to predict that. It might well be the case that there is both a thread toward unity and one toward disintegration, and they are push and pull factors, the resulting net effect of which might tilt toward one or the other, but that's all I can say.
Elaine?
I think as to cyber matters, it's only unity and a very coherent cooperation has been evident through the instrument so far, but it looks like it's early days yet in a situation where you've massive legalization of sanctions taking place day in, day out. So.
Takis?
I think we are in uncharted territory. It is likely that there will be more unity in some areas, but there will also be disagreement, and this will be aired. Overall, if it is correct to say that Europe is forged in crisis, well, this gives us, regrettable as it might be, an eminent opportunity to have closer relations.
And Roman?
I think, I suspect, and I'm pretty much convinced that the war in Ukraine is not only European war, but it's already European war. And this time, unfortunately, Ukraine cannot just frozen and solve this issue by itself. Response must be united jointly by the EU and Ukraine and other international security providers. Otherwise, negative consequences for the whole international security system, and particularly for Europe, are inevitable.
Thank you very much to the speakers for their generosity. We have now, we are 30 minutes over time. Thank you very much also to the attendees for sticking still at this very late hour. And thank you very much also for the questions. Roman, our thoughts are with you, and we really hope that very soon we're going to speak about brighter things, and we are really thinking and praying for Ukraine and for you. Thank you very much. Good evening, everyone.
Okay, bye-bye. I think a great pleasure.
Bye-bye.